Imagine this. You're having trouble recovering a debt. Maybe you're battling a landlord over a missing security deposit, or you're just trying to get compensated for property damages. But the thought of hiring a lawyer and paying those massive, daunting legal fees? Yeah, no thanks. But what if you could actually resolve these issues effectively without ever having to hire an attorney?
Welcome to this explainer. Look, if you're owed money, but you're absolutely terrified that lawyer fees are going to eat up your entire settlement, you are definitely not alone. Thankfully, the Alaska court system has this built-in, incredibly cost-effective arena specifically designed for everyday people who want to represent themselves. It's called the Small Claims Court.
Today, we're handing you a detailed step-by-step roadmap. We're going to guide you completely through the Alaska small claims process, from figuring out if you're even eligible, all the way to actually collecting your hard-earned money after you win.
We'll be tackling this in 6 straightforward steps. We'll cover small claims court basics, prep and filing steps, serving the defendant, hearing prep and procedures, judgments and next steps, and finally, common pitfalls to avoid. Let's dive right in.
Section 1. Small Claims Court Basics. Understanding your arena.
Okay, so before you file a single piece of paperwork, you absolutely have to understand your limits. In Alaska, the financial ceiling for a small claims case is exactly $10,000. Now, if you're owed more than that, you can technically still file here, but you legally waive your right to collect anything over that 10 grand mark. As for eligibility, it's pretty straightforward. Any adult 18 or older, or a registered business operating in Alaska can file. Now, the contrast between small claims and formal civil court is a massive advantage for you. Small claims filing fees are super low, usually just $50 to $100 depending on the size of your claim. But in formal court, you're looking at $150 minimum, plus a ton of strict evidentiary rules. Over here in small claims, there are no juries, there's no complex legal jargon, and you can safely leave those expensive attorneys at home. Section 2. Prep and filing steps. Gathering your tools. Preparation is quite literally everything, and it all starts with the clock. You have got to file before the statute of limitations expires. For written or oral contracts, that is strictly 3 years. For property damage or personal injury, it's just 2 years. And that clock starts ticking the very moment the injury or breach actually occurs. If you miss this window, your case gets thrown out completely, no matter how much proof you have. So you really need to start gathering your documents right away. Your pre-filing workflow is basically a simple 3-step dance. First, you need to demand payment in writing, usually via certified mail, which is often a legal requirement anyway. Second, gather up your evidence. We're talking printed text messages, crystal clear photos of property damage, signed contracts, the whole shebang. And third, carefully fill out Form SC-1, which is your complaint, and Form SC-2, the summons. Take your time with these. Make sure all the names and addresses are 100% accurate before taking them down to the district court clerk and paying your filing fee. Section 3. Serving the defendant. Crossing the threshold. Filing the paperwork is really only half the battle. You now have a strict constitutional duty to notify the defendant, and listen closely, you absolutely cannot just hand them the papers yourself. No way. You must use a neutral third party. That means using a certified process server, a peace officer, or certified mail with a return receipt. Now, if the defendant is dodging you or they're just super hard to locate, you can hire a professional skip tracer or even petition the court for alternative service like publishing a notice in a local newspaper. But whatever method you use, once they are served, you have to file a proof of service with the court. Once they are properly served, the countdown really begins. Alaska law requires the defendant to file a written answer using Form SC-3 within exactly 20 calendar days. And yes, weekends and holidays totally count. If they just ignore the summons and blow past that deadline, you can ask the court for a default judgment, which essentially means you win by default. Section 4. Hearing prep and procedures. Facing the climax. Okay, so if the defendant does file an answer, you're going to court. To keep things moving efficiently, Alaska mandates a very strict color-coded exhibit sticker system. If you're the plaintiff, you put yellow stickers with numbers like 1, 2, 3 on the bottom right of your documents. Defendants use blue stickers with letters A, B, C. And you're going to need 4 identical copies of your entire evidence packet. Why? Because scrambling for loose papers really frustrates the judge. In this arena, organization is absolutely your secret weapon. Now, if you're getting nervous about standing in front of a judge, take a deep breath and remember District Court Civil Rule 9. It explicitly states that formality in pleadings and evidence is not required. This isn't some dramatic episode of Law and Order. The judge knows you are a lawyer. They're just going to ask you direct, clarifying questions. Things like, on what date did the leaks start? Or did you agree to this price via text? All you have to do is speak clearly, answer directly, and literally point to your yellow or blue stickered exhibits to back up your story.
Section 5. Judgments and Next Steps. Achieving Resolution. After hearing both sides, the judge will issue a written judgment. But here is the harsh reality check. The court does not just magically write you a check. They basically just hand you a piece of paper saying, yes, you are owed this money. If the loser refuses to pay it voluntarily, you kind of have to become a debt collector. You can request a right of execution to garnish their wages, though keep in mind Alaska law does protect at least $473 of their weekly paycheck. You can also place levies on their bank accounts or put liens on their property. Oh, and keep in mind, either side has 30 days to appeal the decision to the Superior Court.
Section 6. Common pitfalls to avoid. Navigating the traps. Even in a simplified system like this, there are still some strict jurisdictional and procedural traps that will ruin your case if you aren't careful. First, never try to process a tenant eviction here. That's a completely different court process. Second, never sue for more than that $10,000 maximum unless you are totally fine with forfeiting the rest. Third, do not miss that 20-day deadline to file an answer if you're the one being sued. And lastly, if you do win and you're trying to collect, never harass a debtor. Ignoring the Fair Debt Collection Practices Act can result in them countersuing you for triple the damages, and literally nobody wants that. As a final pro tip, we've got to mention this disclaimer. This explainer provides a highly detailed procedural roadmap, but it absolutely does not constitute legal advice. Every single case is a little bit unique, so if you hit a complex legal wall or suddenly the other side shows up with an aggressive attorney, consulting a legal professional for personalized assistance is always going to be your smartest move. The Alaska Small Claims System exists specifically to give everyday people a fighting chance to get what's theirs without going totally bankrupt on legal fees. You now have the knowledge and the step-by-step roadmap right in your hands. The real question is, are you going to just let that debt go, or are you ready to take your very first step toward resolving your dispute today?